Good morning. This is Rocco Beatrice. I'm the Managing Director for State Street Partners. I want to tell you about a very unique situation that's going to end December 31, 2012. You can give away, if you're single, $5,120,000. If you're married, $10,240,000. In January, it's going to be back down to $1 million. This gift tax exclusion can only be taken advantage if you give away your money to your children, to anybody that you want, utilizing the exemption. Here's how it works. You have an asset, let's say, of $10 million. Asset. Your stocks, your bonds, your collectible, your antiques, your boats, your planes, whatever it is that has a value. Cash. Life insurance policy. If you give it to your children and take the exemption of $5,120,000 single, $10,240,000 if you're married. But the question is, do you really want to give it to your children? What do you think your children are going to do with the money? Is there a better way? Yes. You have to give it to an independent third party for the benefit of your children. So how do you do that? How do you find a third party? Well, it's very simple. An irrevocable trust with an independent trustee. And we add an additional layer of protection called the Trust Protector. All this information is available on our website, so I won't go too deep into it. How does it work? How do you eliminate probate? How do you eliminate estate taxes? The trigger is death. On the date of death, everything you own in your name, titled in your name, your life insurance policy, your real estate, your stocks, your bonds, and so forth, all those assets titled in your name have to go to probate with or without a will. If you have a will, it's a wish list. That's all it is, just a wish. I wish my money went to my brother. I wish my money went to my son. I wish it went to my daughter-in-law. The problem with that is that it's a public record. Everybody has access to your will, a list of your assets. Anybody can file a claim against your assets. Whether or not it's true doesn't really matter. The whole process, depending on the state that you're in, and if you have assets in multiple states, each state has to be probated. You can avoid all that. On the date of death, you own nothing. Everything is owned by your irrevocable trust with an independent trustee. The key is the independent trustee. We add the layer of protection. Let's get back to the $5,120,000. You gift it to your trust. It now becomes a third party. You file the gift tax return. It is a taxable gift, less the tax exemption. The actual taxable is zero. All of this goes away January 1. Don't wait till the last minute. It takes time to implement your trust. It takes time to move title, for example, to your real estate, to your trust. All of this preparation and exactly what are the terms of the trust, who's the beneficiary of the trust, all these kinds of things have to be thought of. We have the ultra trust that we have developed to fit exactly the situation. Now, death taxes, estate taxes, the trigger is death. On the date of death, what again do you own in your name? We know how to avoid probate. On the date of death, you own nothing. That also follows the estate tax, which is the trigger. Death. What do you own at date of death? If you own nothing, you're not subject to the estate tax. The estate tax is a tax on your accumulated wealth that is taxable on the date of your death. If you own nothing, I know I'm repeating this, but if you own nothing on the date of death, you don't have title to your real estate, you don't have a bank account, you don't have an automobile, you don't have a vacation home, you don't have stocks, bonds, collectible art, antiques, boats, planes, nothing titled in your name. One, nobody's going to fight about it. Doesn't have to go to probate. Nobody can file a claim. A bogus claim that has to go through the process of being cleaned up. And the whole process may take 2-3 years. In the meantime, you still pay the real estate taxes, the insurance, and so forth on those assets. And the estate tax, well, you don't have to file a form. The trigger does not trigger. It doesn't fire. There is nothing in the gun. One other thing I'd like to mention. We get a lot of calls with individuals that own businesses. The children may be interested, not being interested in running the business, so forth, or the mother or the father that created the business want to retire. They want to get out of the business. They don't want to do it anymore. What happens is this: they die. The trigger, the estate tax, the probate. The probate process can take 2-3 years because of potential claims that have to be cleaned up. The estate tax is due 9 months subsequent. The IRS doesn't want to know what your story is. They just want their money. Interest, penalties, they just want their money. Forced liquidation of business assets at fire sale prices in order to pay the estate tax. I had a situation just across the street from me. There's a farmer. The farmer died. He has $17 million worth of real estate. It's a farm. They don't have any money, and they can't sell it. There's some restrictions as to when they can sell that, because they took advantage of, in my town, what's called an exclusion for farmland, which they only tax 25% of the fair market value for municipal taxation purposes, the real estate tax. But all of that has to be paid back. So they have a liability with the town in excess of $2.5 to $3 million. They don't have any money, and the estate tax is due. I don't know how that's resolved itself, but still, to my understanding, this happened 3 years ago and still going. The property's up for sale, but there are no buyers. The economy's down. Fire sale prices, it doesn't matter because there's a tax liability by the town that we live in, plus the federal estate tax, and of course the piggyback, the state. By taking advantage of the gift tax exclusion this year will eliminate a lot of these problems. Now, one additional thing. Under certain conditions, that $5,120,000 a gift exemption can be expanded, can be multiplied. As a matter of fact, done correctly, you and your wife could possibly give away $17 to $20 million tax-free, not subject to the estate tax, probate, or any other kind of potential claim by potential creditor, past, present, and future creditor. Thank you very much. This is Rocco Beatrice. For more on this opportunity of $5,120,000, please either call or email us, ultratrust.com. Thank you.